XRP's growth turned into utmost mayhem, especially through the case filed by SEC alleging Ripple for selling illegal securities unregistered in nature.
This is the SEC.
However, what makes them different and perhaps wrong from the SEC side is that these rules of securities must not be applicable for the nature of work that Ripple has been doing through the XRP. We have a lot more to make you jump off your seats now, so stay tuned and watch till the end to find out how to double the money. Today, we will be speaking about XRP and the new twist that took place in the case. This was a move that was totally unexpected and could turn out to be a strategic one to close the case off and call it a day, perhaps a couple of months from now. Make sure you hit the like button and also subscribe to this channel to get the most out of the same. Tell us which one raised your excitement the most and when do you think this case will come to an end? Make sure to enable all your notifications to our channel to keep up with all the hottest secrets in the world of XRP. Also, before we start, allow us to mention that this video is not a piece of financial advice and we are not financial advisors. If you are looking for external financial advice based on your investment portfolio, make sure you consult a qualified financial advisor to make the most of your time. XRP, as we mentioned earlier, has been in a bit of a soup for a long time. With a lot of fear in the market and uncertainties about how this case could come to an end, people in the community have been driven by various different kinds of information. Therefore, we think that it is important for you to know what exactly is happening in cryptocurrency and the case. Before we proceed further, have a look at this document on your screen. And if you don't understand this, we've got your back. If you do, let's learn more. In simple words, the matter written here is as simple as SEC filing a notice of appearance of a new trial lawyer. This move sounds very interesting considering that the case has not been going very smoothly for them. As a lot of their requests were turned down by the judge Sarah Netburns and a lot of the requests by their opposition, that is the Ripple, being accepted and admitted, the case looked like a sinking boat for the SEC already. Let us also look at a change that has been taking shape that could affect not only this case, but the entire United States of America. This is a law that could create differentiation between two of the most important aspects right now. That is, finding a new digital asset against finding new digital asset security. Even though the law hasn't turned into one and will hold value only if it passes before the case comes to an end in the court, we will be able to get more information on what it could mean for the Ripple lawsuit against the SEC. Therefore, understanding this law to the minute details will hold a great value to determine how the case could come to an end and, therefore, your investment strategy. Now, XRP has been pulling back after the bounce-off from the 50% swing low while the case to date sees no end. As the prices kept fluctuating between the supply and demand levels due to the inconsistency caused by the ongoing case, it became hard for the price to leave the said zones and shoot up to higher marks. As we mentioned earlier, a lot of it may be due to the fear that is there in the community. The attack, on the other hand, from the SEC has also been increasing as days proceed. One of the victims is the XRP and Ripple. The argument that we have at the moment is rather a bit more bureaucratic. What we mean by that is that Congress seems to be tussling for power and seems to be claiming that the validity of such concepts is something that needs to be declared by them and not the court. Coincidence or intentional, Congress could come out with a bill right as the case against Ripple was going on in the court. The proposed bill is, in fact, an amendment to the Securities Exchange Act of 1934. The law has been amended in such a way that it takes into consideration any digital asset in one of the two ways that it has. This means that any digital asset that will now exit will now fall under one of these two categories. Considering the fact that the proposed legislation has been under work for a long time now, an elaborate differentiation was something that could be expected. The definitions in the legislature are crystal clear of the digital securities and their definition through Section 101. These will include the cryptocurrencies that are securities, and therefore the regulations of the SEC will be applicable to them. The definition was further detailed down on page 4 of the proposed legislation. There also are lists of items that may be considered to be securities in the eyes of the law thereon. These clauses are as follows. Number 1. Equity or debt interest in the issuer. Number 2. Rights to profit, interests, dividend payments from the issuer. Number 3. Voting rights in major corporate actions of the issuers. Or number 4. Liquidation rights in the event of an issuer liquidation. This was about digital asset securities. The next question that comes to mind is that will the other type be exactly what XRP and other blockchain technologies are? Let us wait and find out more about it. As a matter of fact, the other type that has been defined here is the one that was being referred to by the former SEC employee William Hinman. Looking in at a bit more depth, the basic categorization that is seen among either one of them is that if the money used for the development of the digital platform is not coming out of the sales, unlike a share of a company, then it will be declared as a digital asset. Based on this legislature, it can clearly be pointed out that the XRP will certainly fall in the latter category, that is, as a digital asset and not digital asset security. This also means that no regulations by the SEC will then be applied to the cryptocurrency. However, if this was the only test applicable to the Ripple lawsuit, the case would have by now been over. Let us look at the other side of things. The first question that needs to be taken into consideration is that, by owning XRP coins, will the investor gain any form of voting rights in the company? As any crypto enthusiast will know, the answer will be a definite no. This means that the answer in this regard of the case will be in favor of Ripple. Looking back at the definition, which we already answered back in this video, the question of whether the money from any sale is being used in the development of the cryptocurrency, the answer yet again for this question will also be in favor of XRP. Even though there may have been a certain amount of sales being entered into, the same is something that revolves around the concept that XRP is based solely. Hence, it cannot be considered to be falling under the definition of digital asset security as per the Act. This means that if the case was to rely on that, the chances are that XRP will certainly not be included under the definition of digital asset security. This may mean an instant victory for the XRP case. However, it may be a bit too soon to be decided since the court is still working on bringing a resolution. The next question that could come up is whether the law could be applied retrospectively over the past actions that have occurred. Even though the retrospective application of the law was seen applicable in one of the past cases, which may be held precedent, there are high chances that this may also not be the case. To address the constitutionality of this applicability, the law of the United States clearly declares that the state shall not pass laws on an ex post facto basis. In other words, the laws must not be the tool to impair any contract that exists already. For those who don't understand what ex post facto is, it could literally be translated into after the fact. This originally was to prevent Congress from making people accountable that once was legal, but later after the act was made illegal. Under such circumstances, the state should not get the power to punish the person for something that he did when the act was legal. On the application of this to the Ripple lawsuit, we will see one of the crucial elements of the applicability of this case to be absent, that is, the presence of a criminal action. The second condition for this is that after the verdict law imposes a greater penalty. Since both these elements are absolutely absent from the Ripple case, there are no ways that the charges could be elevated against Ripple. So we have that part of the case sorted out for Ripple. Let us now look at one of the precedents. It was in the year 1994 that the Supreme Court of the United States declared in Landgraf versus USI Film Product that it spoke of application of a changed law while the case was ongoing in the court. The situation that we have in the XRP is also the same. As a matter of fact, the two questions that we answered earlier were a part of this case. Combining all that has been said in the case and in the legislature, there are high chances that Ripple will move out of the case in a very easy manner. It has already been proved through the application of certain principles that XRP is not digital asset security. On top of this, as the new law seems to be in favor of Ripple, the chances are that the law may be applied retroactively, and hence the case may then be concluded, which will mean a fortune for the investors who are waiting to hear this happen. This decision will be based on the actions that the XRP has been taking in the past few months since the start of the coin. Yet again, it could be confirmed that XRP, under such analysis, will be determined as a digital asset and not digital asset security. We hope this video was informational for you and did bring in a lot more insights into what could happen ahead of the case. Make sure you hit the like button and also subscribe here to gain the maximum out of us.